Madam Clerk, item 18, please.
Report to ordinance, parade and public assemblies.
Again, Council, I will entertain a motion to waive the reading of the report, as all members have copies, and there is a copy on file with the City Clerk. Councilman Saraceno.
I make that motion.
Seconded by Mr. Calvo. Is there any discussion? Seeing none, then I'll try your minds on waiving the reading for this one. Okay. Seeing none, then I'll try your minds. All those in favor, please signify by saying aye.
Aye.
All opposed, signify by saying nay. We're now down to the main motion, which is pleasure, Council. Councilman Seabury.
Thank you, Your Honor. I'd like to make a motion to receive the report and to approve the ordinance.
Motion made and seconded by Councilman Trombetta. Discussion. Mr. Rowley.
Thank you, Your Honor. If you please, I would like to make a couple statements regarding the ordinance. Thank you. First of all, I question the legality based upon the constitutionality of this particular ordinance. I think that in some ways that it will be targeting one group over another group in somewhat unfair way, and it goes against my cause to vote for something like this. Secondly, I think that the city of Danbury is placing itself in a position of jeopardy where down the line this ordinance would be found to be unconstitutional and litigation would follow, and it would probably be huge, and ultimately the taxpayer would be the one that would pick up the cost. The next point I'd like to make, and I only have two more, the next point I'd like to make is that there are laws on the books that exist, and our fine police department have always maintained a good job when it came to those people or groups that are spontaneous in a way, in a nice way. I don't think any time that people are spontaneous, I don't look at it as something that is so terrible that we need an ordinance in place. I would recommend that we put in place an educational aspect that would address those groups that might not know the laws, might not know the law of the land, and try our very best to educate them to what is the responsibility to one when they have a spontaneous parade. What are the factors that could take place, whether they might be positive or then also negative. So I think that this is really opening up a can of worms, and we were all immigrants at one time. I'm against illegal immigration, by the way. I'm against it. But I am for immigration, and I'm not for hiding behind a gray area where we might target one and not the other. So I'm going to definitely vote no on this ordinance. Thank you very much.
Thank you, Mr. Riley. I appreciate your comments. Councilman Saraceno.
Thank you, Your Honor. My comments with regard to this are on the record from the other night, but I do believe, and as I said the other night, that we covered the constitutional issues fairly well. And everybody's been focused on the negative parts of this ordinance in public speaking and comments that have been made here. I'd like to ask if I could direct a couple of questions to the police chief about some of the other aspects that are in here.
Please proceed, Councilman Chief.
Chief, if there was a group that assembled spontaneously without a permit and blocked pedestrian traffic or blocked vehicular traffic, they would be subject to action by the police and perhaps arrest. Is that right or wrong?
That is correct.
So if they were to ask for a permit, which there would be no fee because it would be for the sole purpose of their First Amendment rights, then they would be allowed to assemble on the sidewalk or on the street. So is that correct?
Sure.
So the point here being that this actually offers an opportunity for people to assemble by merely letting the police department know so that they can provide the appropriate public safety protection, that the fire department knows that they have to reroute if necessary, things of that sort. Is that correct?
That's correct.
The other thing I wanted to ask you, Chief, before this ordinance, there were fees assessed to groups that had parades, so the Memorial Day Parade and St. Patrick's Day Parade, or parades of that sort, for the police protection that was provided. Is that correct?
That's correct.
And could you enlighten us as to how much that actually cost? Because there was some concern here tonight that this $100 was an egregious amount of money. How much would it cost to pay for a parade if this ordinance were not enacted?
It really depends on the size of the celebration, the length of the parade. It costs several $1,000 to prove what it kind of costs.
Yeah, well, if I'm not mistaken, the 20-minute, half-hour St. Patrick's Day Parade, the police bill was approximately $1,500. Is that correct?
That sounds pretty close. It's sitting on my desk.
So with this ordinance being passed, an organization that wanted to have a parade to celebrate a community event could go for a permit and at most pay $100 and not have to pay these fees if this ordinance is passed. Is that correct?
That's correct.
Thank you. I appreciate your comments, Jim.
Thank you, Councilman. Further discussion, Mr. Cabot.
Thank you, Your Honor. In echoing Mrs. Saraceno's comments, I've been also noted in the public speaking portion the other night at the public hearing and also printed in today's news times. But I would like to ask Mr. Gottschalk if he would address the issue of constitutionality as was questioned here tonight and what his feelings are, since he is an attorney and I am not.
Well, this is just a short answer.
Can you sum it up in 3 or 4 words?
Yes.
Thank you, Mr. Gottschalk.
Reasonable time, place, and manner restrictions are permitted by the Constitution when it comes to regulation of First Amendment rights. You're not allowed to prohibit speech, but you are allowed to make sure that the balance is struck between the rights of some people to speak and the rights of others to enjoy their liberties. So that's what this ordinance attempts to do. Do you want more? There is more.
Mr. Gottschalk, did you have any conversations with the ACLU regarding this particular piece of legislation?
Yes, I can tell you this, that when we started working on this ordinance, we began with a model ordinance, or at least that's what it was represented to be by the International Municipal Lawyers Association. The next thing that happened was that the ACLU questioned some of the provisions in the ordinance that have been proposed by our office, by my office. The next thing that happened was we called IMLA to say, what's going on with your model ordinance? Because some of the comments that we received from the ACLU made very good sense. Some of their objections made sense. And the answer we got from IMLA was that, it was a model ordinance many years ago, and that nobody had done any work to make it the model ordinance of today. And so what I did, as I have done for 30 years when I have questions that raise constitutional questions, is to call on Professor Martin Margulies, who is a retired professor of constitutional law at Quinnipiac. He's also on boards of directors that we share. I've known him for a long time. He's way smarter than me. And certainly will know more about First Amendment issues relating to parades or anything else than I will on my best day. So I called him and asked for his help. He was initially somewhat reluctant because, as it turns out, he was representing the ACLU in an analysis of this ordinance. I said, Marty, gee whiz, we need your help. We're not looking to write an ordinance that the ACLU opposes. And so for the next 3 months, I worked with Professor Margulies and with Renee Redmond of the ACLU to modify the model ordinance so that it would pass constitutional muster today. There, I will tell you, are no guarantees, but this product is infinitely better than the draft that we originally presented to you. It is the product of give and take between my office and the ACLU. It either addresses or considers all of the questions raised by ACLU in a legitimate way. So I will say this about it. You know, maybe I will be proved wrong, and this ordinance will be challenged successfully. But it will not be as a result of blind indifference or malice. It will be with every effort to create a product that accomplishes the goals that you want while not trampling the rights of people in this community to celebrate this place.
Thank you, Mr. Gosher. Mr. Senator, I'm going to work my way down this list.
Thank you, Your Honor. Just a full and fair disclosure, Professor Margulies was a professor of mine back in law school, and the consultation with him certainly sheds very good constitutional light on your deliberations. And this proposed ordinance came to us in response to these impromptu, spontaneous demonstrations, parades, whatever you may call them, that occurred several years ago and occurred multiple times. Before I go on, I want to say that the committee that worked on this and the legal staff that worked on this do need to be commended. This is a very thorny issue, very difficult. They toiled through many other side issues, many lengthy and probably somewhat boring and protracted meetings, and reams of legal research. The problem, though, is that the ordinance doesn't regulate, I think, the very issue that brought this before us. It does not regulate parades does not regulate parades unless they result from some type of prior planning. It even goes beyond parades to public assemblies that result from prior planning, which is not an issue, I think, that brought this issue before us. It affects much more than what brought this issue before us without addressing the initial problem. I think to sit on this dais as a council person and to assure those members of the public that spoke here tonight in favor of this ordinance, that this ordinance will address, regulate, limit, or impact the concerns that brought this ordinance before us that they raised tonight, for me it would be misleading, because it doesn't address those. In prior committee meetings, our deputy chief, our corporation counsel have stated that the impromptu parades, those that lack prior planning, would not be covered by this ordinance. They're expressly exempt, and they must be. You can't regulate something that someone is not engaging in prior planning in order to come up with a plan to present to the city. With regard to the fines, the city's attorney stated at previous committee meetings that the fines could not be imposed on just anyone who participated, but that it would have to be somebody who knew that the event required a permit, and secondly, participated knowing that no permit was obtained, which is very difficult for those who sort of spill onto the streets and join a march. In fact, it would probably be the organizing committee only that could be fined. And with regard to the amount of the fines, the city is limited by the state. If we wanted to impose fines of $1,000 or $2,000 to stop certain conduct, we're very limited. There's state statute which limits city imposed fines to approximately $100 for general safety, health, and welfare. We'd have to change state law, and we've tried in the past, and the mayor has tried in the past, and those have been blocked at the state level. The main problem impacting our residents is not with 25 people, as this ordinance would cover, or 50 people, or 75, but with hundreds of people blocking our roads, blocking our sidewalks, blocking intersections, blocking driveways, which the deputy chief in the past, I think the police chief stated here tonight, is currently a violation of our existing traffic laws, both at the state level and the local level, as well as a bunch of other health, safety, and welfare laws that we have on the books. While even some impromptu parades may have, as we discussed at our committee meeting, some prior planning, some discussion, if the issue came up is if we're watching a game and it's a playoff game and there's a bunch of people saying, hey, if the Sox win, we're going to go run down Main Street. And we're going to beat our horns.
Maybe not the Sox.
Well, based on this season so far. But, I was born in Boston. That being said, but simply a minor discussion is not prior planning under state case law. Prior planning to sort of incur the imposition of the regulation of government requires a substantial step to the execution of what you plan to do. So talking at a bar about getting together after the game would not make it prior planning which is subject to the ordinance, unfortunately, so it wouldn't cover that conduct. Beyond that, though, this ordinance will impose restrictions, I think, on those who obey the law currently, while expressly exempting, as it must under the law, those who break our laws, who break our social compact of common decency to their neighbors, and should be fined, punished, and prosecuted under existing laws. I also think the ordinance goes far beyond regulating parades. For those who may not know, it regulates public assemblies, not just on streets and sidewalks, but in public parks and other places that are owned by the city of Danbury, possibly the state, which could possibly exempt it. 25 people or more gathering in a public place doesn't seem to be the problem. It seems to be many more people gathering on our streets and sidewalks. So with that, what I would offer is the following amendment to allow this ordinance to still afford the city notice of parades, to allow the chief of police to have at least some level of oversight with regard to permitting, but not to go beyond that which seems reasonable. The amendment would be as follows: to amend Section 1115A to increase the number from 25 people to more than 100 people, to remove subsection D, public assembly, and to limit the restrictions or the regulations to those events that would block sidewalks and streets, as opposed to the broader definition covering places, public areas,
Motion's been made and seconded by Councilman Perkins. We are now on amendment to the ordinance as proposed. So any debate would have to relate to the amendment. Any amending of this particular ordinance would require back to public hearing and back to the process again. I just want to make clear that the council is aware of the process. Having said that, any discussion relating to the amendment? Mr. Rotel, then Mr. Thompson.
Thanks, Your Honor.
The amendment.
This ordinance seems to have 4 levels of discomfort for the community that it addresses. The first level, interestingly enough, is essentially nothing at all. The second level is some minor interference. The third level is some substantial interference. This has to do with traffic, pedestrian and vehicular interruptions. And the fourth and final level seems to be closing. In other words, the ordinance appears to kick in when an organizer, again, as Councilman Asadi eloquently stated, this only affects prior planned events, but it seems to kick in or require a permit when an organizer believes there is going to be some amount of interference with the normal flow of traffic, whether that's pedestrian traffic or vehicular. And this applies to both parades, as we know them, people marching down the street, and also...
I just want to question, you're really going to keep your comments to the amendment, not to the ordinance. We'll be back to debating the ordinance once we do the amendment. Go ahead if you want to address Mr. Sadi's amendment.
The amendment is to remove section, I believe it's the assembly definition, which would be 1115D. Public assembly means any meeting, demonstration, picket line, rally, or gathering. That particular section, it didn't really come up when this initial parade ordinance was conceived, because again, the conception of this was to somehow regulate, restrict, or attenuate these massive, at the time, what the community felt were massive, impromptu demonstrations of a parade-like event. And we found out almost immediately that the parade ordinance can't address those. How the assembly ordinance wound up in there, I can't remember. I was not on the ad hoc committee. I tried to attend every one of them, but I don't remember how it specifically got in. I'm sure there was a good reason for it. Probably some sort of way of sneaking out of claiming you're having a parade by saying that you're having an assembly. So mine at the time seemed like a good idea. The problem now is that it's a bad idea, and the reason that this is a bad idea is because the ordinance now is internally inconsistent, and that's a cardinal sin for an ordinance. If the ordinance insists that you have to get a permit...
It's about the amendment, you really want to speak.
Okay, this is about the assembly portion of the amendment. The ordinance insists that you have to get a permit if you're going to interrupt traffic. If you're not going to interrupt traffic, you still have to notify the police, but you don't have to get a permit. The inconsistency is follows, and this is from 1122. This affects both assembly and parade. The chief of police shall issue your permit when he finds that you won't substantially interrupt the movement of other pedestrian or vehicular traffic next to your route or location. The word that they use is contiguous, which means it's from Latin, it's next to. So, you need to get a permit to have your assembly if you think you're going to be interrupting traffic, but the police can't give you that permit if they think you will be interrupting traffic. And that is a very dangerous inconsistency because it essentially means, for the most part, you will be granted your permit. But when someone isn't granted that permit, they can then take us back to court and say to the judge that, look, these guys are essentially ignoring their own ordinance. So yes, it's a good amendment. Let's remove the assembly. Let's send this back to public hearing. Let's remove the internal inconsistencies. There are a few more, and I can speak to them later. But the real problem is putting aside constitutionality issues and whether we think it is or it isn't, or you're in favor of regulation or not. The basic problem with this ordinance that a lot of people worked really hard on and changed and evolved over the last 12 to 14 weeks is that it's now become something that is internally broken and it doesn't need to be fixed. Thank you.
Okay, Mr. Tell. Councilman Taversack on the amendment.
Thank you, Your Honor. On the amendment, I guess knowing that we have 152 sworn officers, when we come down to this issue of permits for public assembly, I wish Mr. Foley hadn't left because I think we could hire him. He could work full-time in our special division of public assembly permitting in the Danbury Police Department. But I want those 152 folks doing police work. And the public assembly inclusion at that low number of one more than 25 puts an awful responsibility on the police department. I like the parade tonight. It was Chinese border torture, but you finally worn me down until you got shot. You know, I think we can't have reasonable time, place, and manner on parades, and there are a few of them. But unless we're going to hire Carl Foley and give him half of our permit center down in the basement for the long lines of people coming in for their public assembly permits, I think we need to adopt the amendment.
Thank you. Councilman, further discussion on the amendment. Mr. Sheehan.
Thank you. Again, on the amendment, I think one of the things an ordinance needs to obtain is two things: is to protect our public, but it's also not to create undue hardship on our police department. By having 25 persons will, in fact, do more harm than good. Because 25 is a very low number. I mean, this counts as 21 alone, and if we were to walk outside, that would be considered a public assembly. But I think if you have at least 100 people, I think that will take some of that undue hardship away from our police and will help manage it more better so they don't have to be day to day accepting permits for 25, 20 people. So in my opinion, I don't think that'll be a problem on the police to handle an assembly of 25 people. That really doesn't cause a lot of traffic violations or disruption to where it needs a permit. So I would hope that this council will again approve this amendment as well. But I'd also like to make a friendly amendment as well, if Councilman Sadi will also accept it, is also on Section 1118 on the applications. So this was also brought up in committee. It was also brought up on at the public hearing as well, regarding the number of days required to be submitted for a permit. Currently, it says 3 days is the minimum allowed, but I guess Chief Baker said that that'll cause hardship to his department, because 3 days may not give him enough time to get the proper number of police to that event. For example, if you had on a Thursday evening at 4 o'clock, I come to Chief Baker and said, I have a permit for 2,000 parades for Sunday. Well, that's within the 3 days that's required. But to give him 1 day to get 20 police officers to that event would be very difficult indeed to obtain. So what he said at the committee, that 5 days is more than enough adequate time to get enough police to any event. So I can make that friendly amendment to change on 11/18 in paragraph B from 3 days to 5 days.
Mr. Sadi, do you accept that as a friendly amendment?
Yes, Your Honor.
Mr. Perkins, do you hold your second for this friendly amendment? Okay. Seeing that, then Mr. Sadi's motion has been amended to public. We're back to the amendment. On this side, I know Mrs. Saraceno had her hand up, so Councilman Brooks.
Thank you. It's no secret to anybody here my passion for this particular ordinance, and being one of those people that worked on the committee. I think that Mr. Sadi's amendment has some merit, but I hate to see us amending this ordinance on the fly like this. So I would like to make a recommendation that we recommit the ordinance to committee and discuss these things. And I'd also like to invite all the people that came here tonight to talk for the first time on this ordinance and bring up issues that we were not aware of, perhaps, or nobody mentioned in the months and months and months that we had committee meetings. Would you please come and participate and make your ideas known while we're working instead of after our work is done?
We currently have an amendment for a motion to recommit that supersedes the amendment. A motion to recommit will, for the council's information, refer this back to an ad hoc, back to a public hearing. I don't believe, is there debate, Mr. Gottschalk, on a motion to recommit? There certainly is debatable. We need a second right now.
Second.
And seconded by Mr. Littell. So the motion would be to refer it back to an ad hoc, which would not have any changes made, would have to go back to public hearing, and we'll see you in about 3 years. Having said that, any debate on this particular issue, Mr. Cometti, you have your hand up, so I know to.
Thank you, Your Honor.
We are on the motion to recommit.
I'm sorry?
We are on the motion to recommit and send this back to committee.
I withdraw.
Mr. Seaver.
Thank you, Your Honor. Just as a point of order or clarification, in order to recommit, is that a civil majority? Thank you.
Say again, Mr. Seaver.
Josh, answer me. The question was, in order for this to be recommitted to committee and public hearing and all that, does it have to be a simple majority to do so?
The vote would be yes, the vote would be a simple majority. Any further discussion on the motion to recommit? Having said that, I'm going to ask seeing none, then I'll ask the clerk to please call the roll. I'm asking for a roll call vote.
Clarification, Your Honor.
Motion to be
Yes, is a recommit.
A yes vote would send us back to committee, back to another public hearing, and a no vote would be to continue on with the debate discussion tonight.
McMahon? No. Negative? No. Johnson?
No.
Rondell?
No, thank you.
Valentino? Perkins?
Yes.
Genie?
Yes.
Esposito?
Yes.
Sadi?
Yes.
Cabo?
No.
Esso?
No.
Vitello?
Yes.
Diggs?
Yes.
Ty Schultz?
No.
Riley?
Yes.
Saraceno?
Yes.
Seabury?
No.
Stanley?
Yes.
Tarasak?
Yes.
Council, back to order, please. Based on the discussion tonight, and based on the fact that we have beat this ordinance to death over the last 10 months, I think it's time we act tonight. I'm going to exercise my right to vote here, which means that there will be a 10-10 tie, which kills the motion to recommend. We'll have further discussion on the amendments as we go. Point of order.
Challenge the chair.
Motion is made to challenge the ruling of the chair. Is there a second to challenge the ruling of the chair? First, let me just rule that Mr. Sadi is out of order. He's challenged that. Seconded by Mr. Shionisi. Any discussion on the ruling of the chair? No discussion. Mr. Gatchuk, did you want to clarify the parliamentary?
The chair may vote to make or break a tie when it affects the result. In this case, the vote stands prior to the mayor's vote at 10-9 in favor. If he 10-9 in favor. If he votes in the negative, so without his vote, 10-9 it passes. With his vote, he chooses to vote no, and it becomes 10-10. The motion fails. So he makes the tie.
So Mr. Sadi has challenged the ruling of Mr. Gatchuk on this. With that, we'll...
With that explanation to the council, I accept Corporation Council's ruling and withdraw my objection or challenge to the chair.
Motion's been made, withdrawn, seconds withdrawn. Go back to the amendment as presented. We have a friendly amendment from Mr. Shionisi.